So welcome to our third panel today. We've had a great day so far, wonderful discussions on a whole variety of different issues. The conference is billed as the good, the bad, and the ugly. We went in reverse order, the ugly, the bad, and the good, and now we're going to finish with the good. We started with Chinese government surveillance of dissidents in Hong Kong. And then, we talked about the Schrems case and talked about a whole variety of different issues in the context of various government actors engaging in surveillance of their citizens and things like that. And then the last panel, of course, we focused on issues of corporate and government surveillance and how different actors respond to that and try to protect that. Today's panel, we're focusing on the good, which is broadly billed as a discussion of two things. One, ways in which perhaps surveillance is a positive thing. It's not always the case that surveillance is a negative thing. There are examples. Anytime we turn on geolocating, right, on our phones, we make a cost-benefit analysis that we want the geolocating to happen so that we can get, through traffic more quickly than we otherwise normally would. So there are obvious examples and instances when surveillance is a positive thing and we opt into it and we're perfectly happy with it. Many people are quite happy to have contact tracing to be undertaken to minimize the chances of infection with respect to COVID. There's a whole variety of ways in which we know quite confidently that surveillance is a good thing. We want the government to engage in a gathering of information to catch the bad guys, right? There's a whole range of examples where we think that the surveillance is helpful and useful and valuable. Even things as mundane as targeted advertising, it's more valuable to have targeted advertising on the internet where you're actually getting advertisements that are of interest to you rather than the advertisements that you see when you watch a football game and you're seeing the 10th advertisement in a row for a Ford F-150 and you're not in the market for a Ford F-150. So there obviously are lots of examples where surveillance is beneficial and helpful. So that's one part of the discussion. But the other part of the discussion is all of the numerous ways in which entities, corporations, nonprofits, other entities take seriously the privacy of their consumers and take very, very robust corporate compliance programs to make sure that those concerns are sufficiently addressed. So we have a great panel with us today. We have Christina Montgomery from IBM and Greg Cram from the New York Public Library. We also scheduled to have Lynn Haaland, who is the Deputy General Counsel at Zoom, but unfortunately she had a commitment that she just simply could not get away from and had to cancel. So we're thrilled to have Greg Cram and Christina Montgomery to talk through the different issues that they deal with from a corporate perspective, as well as from a massive nonprofit organization such as the New York Public Library. So let me briefly introduce, I think I'll start with Christina, and then I'll introduce Greg Cram. So Christina is the IBM's Chief Privacy Officer and Vice President at IBM. IBM is near and dear to everyone at Notre Dame's heart because every single morning we are told to get a passport to come onto campus. We have to fill out the IBM checklist to get a green pass instead of a yellow pass. So we literally are engaged with IBM every single morning, all of us at Notre Dame. As Chief Privacy Officer, Christina oversees IBM privacy program, compliance, and strategy on a global basis and directs all aspects of IBM's privacy policies. She also chairs IBM's Artificial Intelligence Ethics Board. I would love for you to talk about that. That sounds fascinating. Dealing with AI ethics policies and practices. She spent more than 4 years as the secretary to the IBM Board of Directors and led the legal support of many of the company's headquarters and functions. From 2013 to 2018, she was IBM's managing attorney, overseeing the law department's strategic and transformational initiatives. So very long and impressive career at IBM. She's a graduate of Binghamton University and also Harvard Law School. So Christina, welcome so much. We're thrilled to have you with us.
Hey, thanks. Thanks for having me. Do you want me to start talking or you want to introduce?
Yeah, go ahead. Yeah.
Oh, okay, great. Sorry for the confusion. Yeah, hi. No, I was just going to share, a little bit today in follow up to, what Roger said about companies and how a company like IBM encounters privacy, looks at privacy, both from a controller and a processor perspective, because I thought that would be sort of an interesting perspective to share. So I'm basically going to walk you through a day in the life, some of the issues that we encounter here at IBM and how we look at privacy. So it's important, I think, to first start with the fact that when you think of technology companies, we're really not homogenous in terms of what our business profiles are, the data that we collect, the way we approach privacy topics and the like. So we're not a consumer company at IBM. We are a enterprise technology services provider. So we encounter data both as a controller and a processor. As a controller, our reach is global. We're a very large company. We have about 350,000 employees operating in 175 plus countries around the globe. So lots to manage from that perspective, and clients and the like who exist and who we have to service in those countries around the globe as well. You might not think of IBM if you're not familiar. We've been out of the consumer space for a long time in terms of, we used to have laptops. We used to have a lot of sort of forward face, like you would interact with as a consumer product. But now essentially we're the backbone from a lot of the most sensitive industries that you deal with on a daily basis. So we service 90% of the world's biggest banks, 80% of the world's telecom companies. More than half of the retail transactions every day are taking place on our AI, on our cloud products, on our hardware products, our IBM mainframes, and the like. So we're there sort of in the background servicing the clients with whom you're interacting with on a daily basis. And because of that, because we've been managing, and we're 100-year-old, we're actually the oldest technology company that's still around today. And because we've been managing our clients' most sensitive data and deploying sensitive technologies for our clients for more than 100 years, we really depend a lot on our brand as a responsible steward of client data, their most sensitive data, banking transactions, credit card transactions, health data, and the like. And so we've had a CPO. We were actually the first company in our industry to appoint a chief privacy officer. And we appointed one 20 years ago, more than 20 years ago now, at the birth of sort of e-commerce, when you saw, that the amount of data that we were collecting, we were, as consumers and as businesses, able to sort of serve individuals better, personalize things better for individuals. But there was concern being raised about, well, now what happens with that information? And how do you adequately protect it? How do you protect the privacy of those individuals and the like? So that was sort of the birth of e-commerce. And since then, I am the fourth chief privacy officer at IBM. Interestingly, we've all been women, and I am the third chief privacy officer in a row whose name is Christina. So go figure. Just an interesting tidbit there. I started in this role in 2019, and we, under my leadership, reconstituted what the chief privacy role entails. So we had been looking at privacy as a compliance function. It sat in the law department. When I came into the role in 2019, and this is following GDPR, where companies really had to scale their operations on a global basis and ensure compliance across, as I said, the 175 countries that we operate in for our clients and the like. We really came to see privacy, we always had, but even more so, as a strategic value add and a differentiator for the company. So I and my department was moved into the business on a daily basis. I work very closely with organizations like our chief data office, so data scientists and developers and the like, who develop tools that enable privacy compliance and data discovery and the like. I work with our security team, because you can't have privacy without security. So those two things obviously go hand in glove. So they're a daily partner of mine as well. The legal team, and privacy legal in particular, is a very strong partner for myself and my team, as well as our government relations team. Because if there's one thing you note, if you've been following the privacy space, there are new regulations being proposed every day. There really is no uniformity. We help to try to drive that. So, we obviously have principles and practices here that we adhere to, but we do try to inform new laws as they are and to influence them as they're getting enacted to ensure that they're as uniform as possible to enable companies to comply, because the more little differences that you have, the harder it's going to be to actually accomplish compliance and scale compliance, which is critically important for companies that are as big and as far-reaching and as global as a company like IBM. So I talked about controller. So obviously we, under me, I have a bunch of people who manage things like our data subject rights request process and work on tools to help discover data, automate responses to data subject access requests. We provide tools to our business units to make sure they're in compliance with privacy laws and regs. We are responsible for global data privacy assessments, impact assessments when that's necessary, and the like. And then we work in hand in glove with our business units to make sure that the products that we're deploying and the services that we provide to our clients are complying with privacy and security by design and by default. So that's the approach that we take from the earliest stages throughout the life cycle of a product, making sure that we are taking into account the practices that reinforce our commitment to embedding privacy and security into the design of the products, and drive them across the business units. So things like data minimization and adequate data protection, make sure that those considerations are taken into account at the onset of designing and developing a product, for example. Security testing throughout the life cycle of a product, release review, and the like. So working closely with our products and our offerings on that. Some of the things that I've been paying attention to, in addition to ensuring that we're complying with new regulations on a regular basis as they're rolled out around the globe, and as they change around the globe and impact things like what your privacy notices say, just from a pure compliance standpoint, but raising the bar beyond that to instill responsible data practices. I think you heard earlier today about the Schrems 2 decision. So our our strategy is essentially around open hybrid cloud and AI. So from a cloud perspective, there's been attention, obviously, from a Schrems 2 European Court of Justice decision on cloud service providers, particularly US cloud service providers. And if I go back and I mention again, one of the first things that I spoke about, which is the homogenization of tech companies thinking about us all the same, really not. And even cloud service providers, we are not all the same. And Schrems, that decision, certainly not an outcome that we had wanted and hoped for, but it didn't impact us immediately at the time. Although we complied with Privacy Shield, we had standard contractual clauses in place across all our services as well. So we continue to have a mechanism and a means for supporting data transfers. But clearly and significantly, that decision was very focused on government surveillance. So coming back to that point, and government access to data, right? And we are not the type of cloud service provider that gets significant amount of government requests. In fact, we get far minimal numbers. And the vast majority of requests that we get pertain to like account information. Not atypical. And by the way, they don't come from the United States, the bulk of the requests. So we do file a transparency report every year that sort of shares that. But when you think about the, Facebook sort of being the reason why that case was brought, and government access to email content of consumers and the like, that's not us. We've never been subject to a request from the NSA under PRISM. We've never been subject to a FISA request. And then if we do get a request from a government access our clients' data, we tell them, it's not our data. One of our principles is that client data belongs to our clients. So we send that request to our clients. We have a number of commitments that we published when PRISM, became sort of a hot topic back in 2014. We published a letter from our general counsel to our clients that affirmed commitments. It talked about the transparency with respect to government access to data requests, the fact that we aren't subject to FISA requests. We have never gotten one, or a bulk request for data. We committed never to put backdoors. We never have, we never will, backdoors in our products for government and the like. So that letter stands the test of time. As part of the Schrems decision, we're pointing to it yet again. Nothing has changed from that respect. But that's just one, challenge where we are sort of trying to differentiate and demonstrate to our clients that they can trust IBM. Another area where I work considerably is with our technology, our research team, and our technologists. And in our cloud, for example, we embed, and excuse me, I'm just losing my voice a little bit. We're continually focused on raising the bar with respect to privacy enhancing technologies. So most recently, you can read about something called confidential computing. I think technology is going to be the answer to some of the concerns about government access. Because, for example, with confidential computing, which we offer in our cloud, data can be processed without ever being unencrypted. So it's not just at rest, it's not just in transit, it's encrypted all the time. And we don't have the keys. So we couldn't unlock it for a government, even if we wanted to. So these are the kind of solutions that we talk about and help inform. The great part about my job is working with the research teams and working with the policy teams and being able to talk about where do we see the law going? And given where we see the law going, how can technology help us to comply and raise the bar on a regular basis? So that's part of what I do in my job. And then I think the last thing I will cover, and I didn't mention it earlier, part of my role is also to co-chair the AI Ethics Board, as you mentioned. So when I came into this role, I was tasked with operationalizing a centralized governance policy, a centralized governance, or basically format for AI ethics, for vetting opportunities, for vetting technologies and the like, to ensure that they remain consistent with our principles, which are that AI should augment human intelligence, that it should be fair, transparent, explainable, and secure, and the like. So we, thank goodness, in the time of COVID, I'll just give you an example of how that sort of worked. Obviously, with COVID-19, the urgency of responsible tech was sort of highlighted. And we had a lot of interest throughout the company, people who wanted to deploy technology in ways that would help address the global pandemic. So we had our ethics board in place, and we immediately wanted to ensure that we weren't throwing sort of privacy concerns away as we considered what opportunities we were going to pursue and what opportunities we weren't going to pursue. And we published something we called Responsible Use of Data in a Global Pandemic that sort of outlined the guardrails that we put in place for ourselves around these technologies at the time. So things like limits on data collection, strong protections for privacy and security, a commitment to ensure that the technology we were deploying was lawful, fair, transparent, and non-discriminatory. When it came to things like contact tracing tools, we considered like where data is stored, and the approaches that we have taken internally are, decentralized, Bluetooth instead of geolocation, opt-in requirements for solutions that we approved, and the like. And really, these guardrails and the policy points of view that we shared externally and the decisions that we made were really in order to ensure that the technology that was deployed at the time, even in, we use these sort of lens all the time at IBM, but in the pandemic, it was very important to us that that technology, in order to be adopted, that it be trusted and trustworthy. Because, fundamentally, the way I approach my role and the way IBM approaches the technology that we develop and deploy, we firmly believe that technology has the potential to solve so many massive societal problems, but we can't put aside fundamental issues like privacy, like human rights, human-centered approaches to technology, or we're not doing it the right way. So that's just a sort of high-level day in the life.
Great. Thank you very much. That's fantastic. I think we'll have Greg do a presentation next, and then we'll do Q&A after that, Christina, if that's okay. So Greg Cram is the Director of Copyright Permissions and Information Policy at the New York Public Library. Query, Greg, whether that's the largest library in the country. I assume it probably is, right?
It is, yes.
I forgot to ask you that in advance, but that was
at least we claim that it is, so it is.
The Library of Congress might disagree, but
it might.
You've been with the New York Public Library for 10 years. Since 2019, as I said, you've been the Director of the Copyright Permissions and Information Policy. Before that, for about 7 years, the Associate Director in that. You are an adjunct professor at NYU, and then you did your degree, your law degree from Cardozo in 2007, and have an undergraduate degree from Boston University. And we specifically asked you to join us to speak about the role, I guess you could say, you're not a corporation, you're an intermediary, I guess, between users and various entities that might want or desire access to the information of your users. You have no profit motive whatsoever to share that information as a nonprofit entity. So please just give us your thoughts generally about the New York Public Library and similarly situated entities and how you deal with these sorts of issues.
Great, thanks, Roger. And I'm going to share my screen here so you all can see. So thanks for having me. So as Roger said, libraries have been slotted into the good slot today, but libraries are not immune from the challenges that we've been discussing all day. For 100 years, we've been focusing our energy on the physical objects in our collections, and the privacy issues posed in dealing with a physical collection are real, but they're somewhat manageable. We know how to deal with them. It's been 100 years. But we're increasingly shifting our focus from the book stacks to server racks. And that means we're digitizing more of our collections, accessioning more born digital material, and subscribing to more online databases, all in an effort to meet the evolving needs of our users. And this is an important shift for cultural heritage institutions, the shift from patrons coming to our physical locations to access information, to us being able to serve content to them, to meet them where they are online, raises a whole host of new privacy concerns for us. And I know a question has come up repeatedly today: how has this changed in the time of COVID? And this problem is even more pronounced in the time of COVID, where libraries like mine are closed or somewhat inaccessible to the public, but the public still needs access to the information. This shift from to digital means that there are more opportunities to collect data on our patrons, for better or for worse. Today's symposium has revealed how complex these issues can be. And in this last panel, my role is to tell you a little bit about these challenges that we face as a not-for-profit. So as Roger said, I'm the Director of Copyright Permissions and Information Policy. It's a long title. What does it mean? It means that I'm the copyright person at the New York Public Library. I was hired over a decade ago to focus on intellectual property. But as we mentioned, there's another part of my title around information policy. While I'm primarily focused on IP issues, the intellectual property issues, the information policy concerns of my title means that I often play a supporting role in reviewing new policies that impact how our patrons can access and use our collections. When I was hired, I was told that I had two jobs. First and foremost, expand access to our collections, both in our physical spaces, but also in our digital spaces. My job is to work with curators to increase access to our collections as broadly as possible so that our collections can inspire the creation of new works, new information, new aesthetics and insights and understandings to advance the progress of knowledge and society. My second job is don't get sued and lose don't get sued and lose, and do those two things in that order. Because copyright information policy is so fundamental to what I do, I'm increasingly finding myself engaged in public policy conversations. And a few years ago, I testified on behalf of the New York Public Library in front of Congress about a copyright issue. We've been tracking the emerging emphasis in Congress to look for privacy legislation, although no obvious compromise is around. We keep monitoring the situation because of our role as a library. For those not familiar with the New York Public Library, we are a public library in New York City. We were founded in 1895, and we are the nation's largest public library system. You've got a theme on this panel of large old companies. We feature 88 neighborhood branch libraries throughout the Bronx, Manhattan, and Staten Island, and we have 4 research centers that house world-renowned collections, including millions of treasures. Our collection contains works that range from a copy of the Declaration of Independence, handwritten by Thomas Jefferson, to the archives of Ossie Davis and Ruby Dee. Before COVID, we welcomed more than 16 million visits to our physical locations and nearly 30 million visits to our website. We've circulated over 21 million items last year, or 2 years ago, and hosted over 100,000 programs. Our 2.4 million cardholders and millions more accessing our research collections remotely depend on the library for critical services to advancing the progress of knowledge. The library provides services for our youngest patrons who are just starting out to learn how to read, to lifelong learners who are learning new skills or trying to understand complex areas. Authors, songwriters, dancers, and Supreme Court justices have all graced our stages for public programs to discuss the matters of the day and to talk about their books. It's a really inspiring place to work. I love what I do, but it's also inspiring for another reason. And that reason begins with a story. In 2005, 2 FBI agents appeared at the door of the library and asked to speak to the boss. The director brought them into a private office space and shut the door. One agent then explained that they were there to demand all information, including visitor logs, access logs, and any other data related to the use of the library's computers on a particular day. The agents indicated that this was a matter of national security to, quote, protect against international terrorism, end quote. The order wasn't a search warrant or a judicial order. Instead, the order was in fact a national security letter. As part of the response to 9/11, Congress passed the USA Patriot Act, and as part of this act, FBI agents could use national security letters to obtain library records if they were conducting an investigation to obtain foreign intelligence information not concerning a United States person, or to protect against international terrorism or clandestine operations. So while handing over the national security letter to the library director, the agent said to the library director, "It is a federal criminal offense to discuss this matter with anyone. Do you understand?" And that's because the FBI could accompany national security letters with a gag order forbidding their recipients from disclosing that they had even received the inquiry under penalty of being fined or jailed up to 5 years. So the library director, believing that the gag order to be unconstitutional, an unconstitutional restraint on speech, gathered his executive team and passed around the letter and said, "What should we do?" Later, a lawyer joined in and explained that by seeing the letter, each of the 4 were now subject to the gag order and could only be relieved from the gag order if they sued to remove the gag order. They went to the ACLU to seek assistance resisting the NSL, as well as challenging the gag order that in the provision in the Patriot Act. Challenging the NSL and the gag order put all 4 in potential personal legal jeopardy, and if it were ever disclosed that the library had resisted an order originally intended to prevent terrorism, each faced personal blowback and threats of protecting terrorists. In fact, at one point during the proceedings, a reporter for the AP called the director's house and asked the director's son, who had no idea that his father was involved in a national lawsuit about national security letters, asked the son what he knew about the FBI investigating his father. So why challenge the NSL and the gag orders to take on these risks? Well, it's because of the library's central role in American life and the role that we've played for over a century. American libraries were founded on the conviction that democracy could only be furthered and our union made more perfect if members of the public were able to educate themselves. By educating themselves, they would become an informed electorate to allow them to make informed decisions, and libraries believe that an informed citizenry is an essential element to democracy. So instead of hoarding our information and locking it away, libraries are instead focused on making their collections as broadly available as possible. To encourage the use of these collections, libraries believe that patrons must have the ability to read, research, or study without the threat of surveillance or interference. If library patrons believe that their library activities are being surveilled, it's likely the patrons would just limit or change their behaviors in ways that would impact their right to read. We have categorized this or packaged this into a phrase called intellectual freedom. And to ensure intellectual freedom, librarians are committed to the privacy and confidentiality of their patrons. Privacy is essential to the free inquiry in a library because it enables library users to select, access, consider information and ideas without the fear of embarrassment or judgment, punishment, or ostracism. For the marketplace of ideas to exist, patrons need privacy to be able to explore controversial concepts or proposals, so much so that it is written into the professional code of ethics that librarians operate under. Libraries have used many tools to preserve the confidentiality of patron records. Many libraries, for example, regularly destroy the records of which books have been checked out by the particular patron once the books have been returned. This practice is not only encouraged by our professional ethics, but in many cases it's required by law. For example, in New York State, when the New York legislature was considering shielding library records from ordinary disclosures, the legislator wrote a really nice passage about libraries. They said the library, as the unique sanctuary of the widest possible spectrum of ideas, must protect the confidentiality of its records in order to ensure its readers' right to read anything they wish, free from the fear that someone might see what they read and use this as a way to intimidate them. Records must be protected from the self-appointed guardians of public and private morality and from officials who might overreach their constitutional prerogatives. Without such protection, there would be a chilling effect on our library users as inquiring minds turn away from exploring varied avenues of thought because of the fear of the potentiality of others knowing their reading histories. I think it's a really nice passage from the New York State legislature. So when these Connecticut Four were faced with this disclosure of confidential information of many patrons who were not the subject of the investigation, they were following their professional ethics and resisting. Remember, the FBI wanted to know the names of everyone using the library's computers at that time, presumably to connect someone's internet activity with a name, except that the individuals that were not of interest to the FBI would have been swept up in this order and would have had their privacy violated in the views of these librarians. So after a year of litigation where the librarians were forbidden from attending the trial in person for fear someone might recognize them and blow the gag order, the DOJ ended up withdrawing the NSL demand and even dropped the gag order completely. It's unclear how many NSL demands have been made of libraries since the enactment of the Patriot Act, and honestly, we may never know due to the lifetime gag orders that some feel they're still under. Okay, so although government outreach or overreach and surveillance is one threat libraries face, we've talked about other threats today in the symposium, and there are other threats that are more insidious than government overreach. For example, libraries supplement their collections by working with third-party vendors regularly. These vendors provide an important service to libraries and their patrons by providing database subscriptions. These databases are attractive to libraries because they either contain items that are not in the library's collections, or the database vendor has added value to the items by enhancing searchability, discoverability, or other features that help patrons. For example, three vendors that you might be familiar with here at the law school, Westlaw, Lexis, and JSTOR, probably entities that you've all used. There's one such database vendor, lynda.com. They provided our patrons video courses that were taught by industry experts, and it's a heavily used collection by our patrons. When we talk about these databases, what we're talking about are libraries paying for a subscription fee to the service. So there's an incentive to make sure that the people accessing the service are actually library users. The way access is normally accomplished is that a patron locates the database on the library's website. The library then validates that the patron's library card number is valid and then connects the patron to the service, usually through some kind of proxy service to give the patron some anonymity. In 2015, this lynda.com service was acquired by LinkedIn, and then a year later, Microsoft acquired LinkedIn, including the lynda.com platform. And when they acquired the platform in 2019, libraries told libraries that lynda.com was going to be rebranded as the LinkedIn Learning Database. and that all library users would need to register their accounts with LinkedIn Learning, even if they were utilizing the library subscription. In other words, the patron would have to accept Microsoft's terms and conditions, including its privacy policy. They would permit Microsoft to track patrons in all of the ways that we've discussed here already. As you might guess, individual libraries objected to this change, and they demanded changes and even organized to raise public awareness of the issue. But this time, however, they're not fighting the federal government. Instead, they're up against Microsoft, a large multinational company that wasn't really interested in libraries or reversing its decision. In fact, they dismissed us so much that there was a blog post, and this was the response in the blog post to libraries. It includes this nice patronizing line. We recognize that this is a change for both librarians and their patrons. Our commitment to you is that protecting our members' trust in data is our, quote, first priority and guiding principle. If you recall, just a few years earlier, LinkedIn suffered a data breach that impacted over 117 million accounts. And that was after LinkedIn apparently failed to follow standard protocols, including not salting their hashed credentials. So, first priority. Cory Doctorow took a look at this blog post and interpreted it for us. His statement was much more concise. He read it to say, drop dead. So libraries were left with this choice. They could either cancel their subscriptions and frustrate their users who really enjoy the lynda.com service, or give in and violate their core ethical duties. Faced with that stark choice, libraries found a third option, which was to attempt to raise the public profile of the issue beyond academia. And after a few discussions, a year of discussions, threatened cancellations, pressure, and bad press, Microsoft finally relented. Sticking to the first principles and being willing to walk away from a vendor is tough. And I commend these libraries for being willing to walk away when they were challenged, when their privacy principles were challenged. But this pressure to give up information to vendors is regular and consistent and isn't going away anytime soon. This is something the libraries will continue to face as we make more and more of our data available in these databases and connect our users to these databases. And that brings me to my final threat. My final threat to libraries and privacy is actually libraries themselves. Libraries are on the forefront of providing information to patrons using online platforms. More and more services and resources are moving online and to the cloud. And this shift in providing digital services means there are lots of opportunities to collect and store data at little cost to us. This shift to access the information using digital technologies as opposed to analog technologies presents libraries with a really great opportunity, and that opportunity is personalization. Libraries strive to provide the best service to patrons and meet their expectations, and our patrons for the last decade or two have been exposed to things like this, the recommendation engines from Amazon or Netflix. These personalized recommendation engines are based on a number of factors, including the previous history, previous purchase histories, and interactions with the platform. These engines are possible through massive data collection and surveillance of these interactions, but some users find them useful. Libraries, too, could collect this data to provide personalized recommendations. For example, if the library was having an event with an author and we knew you had checked out a book by that author in the last 6 months, we could target you with advertising for that event. Now, you might find that helpful and perhaps you expect that to happen, and maybe that's a good thing that we can find your interests and tell you about them. But that comes at a cost, and that cost is the privacy erosion. Libraries today are feeling the pressure to make services even more integral to people's lives. They're feeling the squeeze from marketing departments and patrons who want that personalized service. And as we've heard all day, user data is like gold, and libraries are willing to throw away that gold every day. That's crazy to some folks, and that is unacceptable to others. But for us to build out a successful personalized experience with the library, that means we'd be needing to do data collection and retention at a pace that we've resisted for over a century and would fundamentally change how libraries operate. But feeling the squeeze, there are some libraries like ours that are developing internal guidelines to help navigate these complex issues. Some libraries are creating guidelines and rules to help staff across the library, not just the librarians, understand the data collection practices that will be accepted by the institution. When decisions are close calls where the guidelines are not necessarily clear, don't resolve the question, there are often teams of senior leaders that act as a tribunal to hear the issue and make a decision that is then shared with the rest of the library so everyone understands where the library's position is on these privacy matters. I'm proud to say that my library was one of the only, maybe the only public library out there to have created a position focused solely on privacy matters. This is Bill Martin, the Director of Privacy and Compliance at the library. Our Director of Privacy and Compliance provides a wealth of knowledge on these issues, and he's also part of the process to review any new databases or services from outside vendors to confirm that they are in compliance with our privacy policies, values, and guidelines. Sometimes his work slows things down and makes sure that we investigate things, but that's exactly why we hired him and why he's part of the organization. One impetus for Bill in this position being created was actually a blog post from a security researcher interested in challenging the notion that libraries always get privacy right, that we are some cherub among all other institutions. The researcher identified a number of places where libraries are leaking data to third parties, especially when libraries installed widgets for third parties on their unsecured sites. Those widgets could potentially read search terms that were being entered and track users in ways that libraries didn't expect. Adding Bill's position has been a boon to the library's adoption of the privacy by design principles when building out new services, technologies, and procedures that we've been focused on for the last few years. So of the three threats we've discussed, this threat may be the most difficult for us to resist. After all, while we may be afraid of what a state entity may do with our data or what a big Facebook company may do with our patrons' data, libraries sometimes believe that their own collection could never do any harm. After all, we're in the good column, and I'm in the good section here, not in the other sections. But as we've heard today, that's not always the case, and despite best intentions, we may not always be the best actors. So these pressures from state actors and vendors and even our own patrons are pushing libraries to grapple with their approach to privacy and confidentiality. And when libraries flag problems that put our patrons' privacy at risk, we often get this pushback, this familiar refrain that you've heard today, who cares about privacy, right? We do. And everyone on this call cares, but our patrons are willingly giving up their privacy outside of the library context pretty regularly. Some are willing to give up even more data for the convenience of having, for example, a single login managed by Facebook that reveals to Facebook all of the sites a user visits and all of the data that the user is accessing. And we've heard this phrase today, if you're not paying for it, you are the product. By design, library services are free. Our patrons don't directly pay for the services that they're using by design. But unlike other gratis products that are really data aggregation services, libraries so far have mostly rejected this temptation to share data. And this is why I think the pressures faced by libraries for collection and sharing of more data will actually be turned away, and that libraries will succeed in their ability to protect patron privacy. Libraries are this unique sanctuary of the wildest possible spectrum of ideas, and libraries can stand apart from the rest of what's online by maintaining their strong positions on protecting patron privacy when those patrons use library services. As Christina said, IBM is differentiating themselves based on privacy, and I think libraries can do the same. Patrons don't have to be the product when visiting a library to research whether their new cancer diagnosis means to them. Instead, they can do their research without fear of ads following them around the internet, trying to sell them the newest fad in cancer treatment that is merely the modern version of snake oil. They can come to the library and use the library's computers to research shelters to develop an escape plan to leave abusive partners without that partner being able to see the internet search histories of that person. And patrons can explore new ideas and controversial topics so they can become more informed citizens and experience personal growth, which advances the goals of democracy. So by distinguishing themselves as a place of intellectual sanctuary, I think libraries can remain in the good column for plenty of years to come. Thanks, and I look forward to the conversation today.
Great, you want to take that down? Yeah, thank you very much. Great, so we have a huge list of questions already in the chat. I encourage you, if you have not done so yet, please refer your questions to the staff, and they will then upload it into the Google shared document for me to ask to our panelists. Let me just make a brief comment. I had a very, very fruitful conversation with Lynn Haaland, who is a Deputy General Counsel at Zoom and was intending to join us today, but had to cancel at the last minute. And she really wanted to emphasize to me in our conversation, and she was going to share with the audience, that you really have to focus on the incentive structures of the different companies with respect to how they will treat privacy. And I think Christina mentioned this already, but to the extent that a company makes money through advertising, their incentive structures are going to be very, very different with respect to privacy than other companies that are subscription-based or have other means of revenue, or in the case of things like the library, are not really pursuing revenue as their objective. And she said, for example, Zoom never sells any of its information to anyone because that's just simply not its revenue model at all. And it, in fact, focuses its features as being very, very privacy enhancing because it knows that that's going to be of critical importance to their consumers. We all are aware of some of the early concerns during the early stages of the pandemic about Zoom bombing and about various password protections and potential breaches related to that. But for a company like Zoom that is public facing, it's not a back office company, but on the other hand, its revenue model is very much based on subscriptions, not based on advertising. It has every incentive to try to enhance the privacy of its consumers. So I was just wanting to invite both Greg and Christina to sort of talk about the different revenue models and how that impacts the privacy protections that different companies have. I mean, I was thinking, Greg, as you were talking, that you basically said that your primary goal, you have a very, very fundamental primary goal to protect consumers' privacy. Google, you could also say, is a library in many respects. It has a fantastic repository of information on Google Books and Google Scholar, and just a wealth of information. They might challenge your assertion that New York Public Library is the largest library. And obviously, though, they have the opposite incentives, right? Their incentives are to gather as much information as they possibly can about everyone and everywhere they're going with respect to what they're reading in Google Books and in Google Scholar, and then use that as part of their aggregation of the composite of the profile of the individuals, so that they can then sell that to advertisers that are wanting to buy premium information for targeted ads. Can both Christina and maybe Greg just sort of speak about the way incentives and revenue models change the sort of privacy landscape for the different companies? I don't know, Greg, if you want to start, or Christina.
Why don't you go ahead, Greg? It's
okay.
Good follow-up.
So the incentives, for libraries are pretty clear for us. We are private not-for-profits, or we are government entities in some cases. The New York Public Library is a private not-for-profit. So the incentive structure here for us is really to achieve our mission, our nonprofit mission, to increase access to knowledge and make sure that increased access to knowledge follows or causes more knowledge to be created. So that's great. But I think the incentives for Google are a bit different. And I will say, we are a partner. We are a founding partner in the Google Books project. Google definitely came to our library to digitize materials and continues to do so today. And so my lynda.com example is an example of us resisting kind of sharing patron data with vendors like this. But libraries have to make some difficult choices sometimes. The incentives for us are to make sure that we are meeting our mission and meeting our users' needs. Just because I satisfy our mission doesn't necessarily mean that I remain popular within the community. And budgets are always tight. So libraries, while not always the first thing to go, are sometimes. And so libraries have to remain relevant and have to fight to remain relevant. So while there is not an incentive for us to collect a whole bunch of information merely to repackage that data and sell it to other folks, there is an incentive for us to provide services to patrons that are more appealing to them or more interesting to them. For example, I would love to be able to know when someone stops reading a book, an ebook, for example. Like, did they stop reading the ebook on page 1, or did they stop reading it on page 90? that might tell us something about their interests in that book, or maybe they ran out of time or whatever, but at least I could know a little bit more about their reading patterns if I got into, seeing their reading history. There's an incentive for us to be able to do that because we could then provide better recommendations to those patrons. But that is really creepy. It is really creepy to be able to look over someone's shoulder and see which page they stopped reading a book on when they returned or the book was auto-returned. So I think the incentives, while they're different among each of us, I think that there are still incentives to actually violate people's privacy in order to even achieve nonprofit missions.
Great. Christina?
Yeah, so this comes back to the business model and the comment about homogenization. So we're an enterprise technology provider. Our clients' data is their data. We also, even if they're a cloud, if they're using our public cloud, for example, the insights that are produced by having their data on our cloud are not owned by us, they're owned by the clients. Our agreements are very transparent in that regard. So we're not looking to make our services better to that extent with like private information from clients and the like. So it's a very different business model. I think it's something that isn't necessarily fully understood because, again, we're thrown into this bucket of cloud providers, so to speak. And the big clouds are the AWSs of the world and the Microsoft Azures of the world and the like. But yeah, I mean, they're fundamentally different business models.
And so the defaults on privacy in the sort of terms of service are going to be different as well, right?
Yes, absolutely.
Can you speak about where we're headed going forward? One thing that I've noticed in the past 5 years is the landscape about privacy protections, the whole discussion has just dramatically changed, probably first and foremost with GDPR. I mean, just a massive epical change, I think, in Europe with GDPR, and then of course the California parallel to that. We've had some discussion about that over the course of the day today, but can you sort of, from a sort of corporate perspective, can you sort of talk about GDPR, the California state law on privacy, and then various federal and state proposals going forward?
Yeah, I mean, I think what you're seeing, so GDPR was first out of the gate, and it sort of has been, for many companies that are trying to, that operate on a global basis, it's sort of our baseline. It has to be because it was the first, it's the controls that we put in place and the like. Then comes CCPA in California. So basically now that becomes your baseline, but they're very different. One is about, selling, and the definition of sale is not a typical one. So that requires certain changes to your practices across the scale. But what we're seeing this year, and I think this comes back to the question too of what COVID-19 has done with respect to attention on privacy and the need for privacy legislation. And I think it's a combination of the Schrems decision out of Europe, as well as COVID-19 and a new administration. I think we're seeing more and more states become active with respect to wanting to set standards for their citizens, wanting to provide their citizens within their states with equivalent rights. And so at IBM, we have been advocating for many years for a national standard. We think that there should be in the US a consistent, strong set of consumer rights that are applied, that consumers have regardless of where they live. It's just not practical for consumers to expect to have different rights depending on where they access the internet, it's a completely irrational approach in many respects, right? And it's not possible for companies to comply with 48, 50 plus different regulatory standards in the US. So we advocate here for, and I do this on a regular basis, advocate through stakeholder groups, individually, for strong, consistent national protections, and that give consumers rights to do things like opt out of having their data collected in the first place, but when it is collected, have the right to access it, to delete it, to correct it, and the like. Enhanced protections for sensitive information at a minimum, being sure that if sensitive information is being collected and stored, that be consent-based, and that there be enhanced security protections around that type of thing as well. accountability on the part of companies, and having that be roles-based accountability. So similar to the GDPR, where the controller has they're the ones who have the relationship with the consumer, and so different obligations with respect to what they should do. They determine the means of handling consumer data and the like, and then a processor and what the obligations are there. So roles-based accountability and sort of a risk framework as well, because obviously, look, we're a technology company and we want to support technology innovation. So we have to be careful about privacy law that will hamper innovation without providing a corresponding benefit to consumers. So that's what we're hoping. Again, we'll continue to advocate. So now in the US, you've got Virginia, which is right on the edge of passing consumer privacy legislation. That bill could be signed into law by the governor probably, maybe even as soon as the end of February. And then you've got states like New York, I believe, Utah, Washington State. You've got the CPRA in California, which is sort of that passed on the ballot initiative in November. And that is essentially expanding the CCPA, the existing regulation, and making it more, I would say, GDPR-like. So again, if we don't have some kind of harmonization, it's going to be more and more of a challenge. So we'll continue to advocate for national privacy legislation here.
Greg, do you want to add anything to that?
Yeah, I'll just add from the consumer side, or from the patron side, as we call them, we have seen an increase in interest from patrons about privacy. And you might be able to tie some of that back to some of the larger data breaches that have happened over the years. Equifax in particular kind of drew a lot of patrons' interest into privacy matters. So I think from an education standpoint, we're seeing more and more interest from the public who wants to be engaged on privacy matters, who are seeing Cambridge Analytica. They're seeing some of these stories make national news, and they are interested in understanding how their data is being used. So I think from the consumer standpoint, I think there is interest. Is there overwhelming interest? Is there demand to knock down Congress's door to get that national harmonized bill? I don't know. We haven't seen it yet. What we're hearing is that a lot of companies are facing the same problems that Christina just mentioned, that they need harmonization, and therefore they're the ones who are driving some of the change in Washington, or trying to drive some of these changes. And we're not sure yet whether consumers are really at those tables, because we haven't seen kind of the intense interest from the public. We have plenty of good organizations who are representing consumers at those tables, but just kind of a more overwhelming national interest would, I think, make those bills even better.
Yeah, I would agree with that.
Yeah. So Christina, does that mean, given that different companies have different incentives, that you would love a sort of federal national privacy standard? I assume that many other companies want as little privacy as possible, because that's their business model. So am I right to say that a whole variety of different corporations are taking very, very different views on all of these different proposed regulations? Is that accurate?
I would say of the large corporations, a lot of the advocacy that we all do is through trade associations that we're members of, like the Business Roundtable or the Chamber of Commerce. For software companies like IBM, it's the BSA, the Business Software Alliance. There's general uniformity, I think, because companies recognize, there's obviously places where there's divergent perspectives, for sure. And it's particularly true in the advertising and the targeted advertising space, where companies who are monetizing data have much more of a stake in terms of what, the impact that a national privacy framework would have on their day-to-day business practices. Right. But for the most part, there's uniformity. And I think it comes in part from, what consumer groups, you do have to maintain a reputation. And as consumers get more and more interested in privacy, and I agree, to some extent, there's, I talk to my own daughter, and she doesn't seem to have very much concern, there's a generational, I think, interest in this topic as well. And there doesn't seem to be quite as much concern about sharing as I don't know, want to make any stereotypes, but I know from my own experience in speaking to, her, there doesn't seem to be as much of an interest as one would think. But overall, there's general uniformity. I think that too, on both sides of the aisle in the US, right? I don't think privacy is partisan. There are some sticking points for federal legislation that, the two sides, that has really held back kind of reaching, I think, agreement at the national level. But for the most part, I do think there is uniform agreement in Congress and among companies in general that consumer rights should be granted with respect to their personal information.
So I think we only have time for maybe one more question. We're moving everything up by 15 minutes because of the fact that we have one less speaker, and David Kay will be joining us at 4:15. So maybe, Christina, can I ask, a student question came about facial recognition. And, the obvious risks of facial recognition, there's an incredible amount of privacy. Once you have that facial recognition, that's an immutable trait of a person that's never going to go away. And once you get that, it's a permanent feature of the database about that person. So are there ways that IBM or other type of companies are taking steps to protect against the misuse and nefarious aspects of facial recognition? The one example the student gave was, for example, racial profiling.
Yeah, I mean, we don't offer general purpose facial recognition technology. In fact, we were the first company this summer to explicitly come out with that position externally, to say we do not think that now is the time for general purpose facial recognition technology to be deployed. At least from an IBM perspective, we're not in that business. So we also have made some concrete policy recommendations with respect to facial recognition technology. So we do think regulation is required for this technology at this point in time. And we have called on, if it is going to be deployed, it's not going to be deployed by us. At least not, it won't be our software or our tools or our algorithm at this point. But our precision regulation recommendations revolve around, they sort of distinguish between the facial recognition that you use to get into your phone, that sort of one-to-one match with consent, where it's residing on your phone and, not broadly used to authenticate your identity, that type of thing, versus, we've been very clear consistently that we don't agree with one-to-many matching systems, and particularly used for racial profiling or mass surveillance purposes. So, that's where we are. We've been pretty clear on that point.
And how do you deal with mass surveillance demands from foreign governments? I mean, obviously, I know it's not a common concern in the United States, but there are countries that do want to do that sort of mass surveillance. Maybe that's not something that IBM specifically has had to deal with, but is that a legitimate concern?
Yeah, I mean, there was an article on Oracle in The Intercept this morning that talks about, their relationships with China. I mean, I think, not trying to throw a company under the bus or anything, but yeah, I mean, I think there is, and that's part of the reason why having the ethics board in place is very helpful from an IBM perspective to instill a centralized decision-making and accountable framework. And we do make different decisions based on technology, depending on the end use and the end user. That's part of, you need to have a very risk-based approach to this type of thing. We don't typically say we're going to stay out of a particular category of technology, but we did with respect to facial recognition, general purpose facial recognition. And we've called on the government, the US Department of Commerce, for example, to add facial recognition technology to the control list, so that, the same control list that military products are on, so that it can be tightly controlled and prohibited for export to certain countries. So, yeah, I mean, the concern is without regulation and without restrictions like that, it won't be the IBM of the world, but there's going to be some company, right, that's going to sell that technology, and there will be governments around the world that will misuse it. So, yeah, I think there is concern.
Yep. Greg, final question. We talked on the phone yesterday. How do you deal with legitimate government requests for information about the use of library resources. I gave you the example of Zodiac, the movie Zodiac, where they basically figure out what books the suspect was reading to figure out who the Zodiac killer was. So is this a common issue where, you know, you have law enforcement trying to figure out the behavior of your patrons for law enforcement purposes?
I'm actually, it doesn't happen as often as you would think. Most often, I think, are the requests for video from cameras that are facing outside of our buildings.
Right.
So a crime happens down the street, they run by. Now the NYPD wants to access that stream. And for us, I think, you know, I think you might be able to draw a distinction between what is a library record, what happens when you enter the sanctuary of the library versus what happens outside the library, right? And I think that we treat those requests perhaps a little bit differently. Whereas, you know, we might not put a camera inside a library because we just don't want that data to be there. But I think there are plenty of opportunities. I mean, if there are legitimate law enforcement interests and those interests are signed by a judge, I think that really, the libraries are compelled to comply. I think the libraries will resist and try to narrow those requests down. So in the case of the Zodiac killer, instead of, you know, trying to go through all of the patron records to find who checked out this particular book, you could trace that you go through all of the books and find those things and then isolate back down to a single person. So I think that libraries are trying to narrow those demands as much as they possibly can so that innocent folks or folks who are not subject to the investigation are not swept up in those evidence gathering raids.
Wow. Well, this was fantastic. We filled more than enough time with two speakers. It would have been hard to finish everything if we had a third panelist. So I just want to thank you so much and appreciate it. We look forward to our next keynote final speaker in about 10 or 15 minutes. So Greg, Christina, thank you very much.
Thank you.
Thank you.